Thanks everyone for joining us. This Financial Poise webinar, Structuring and Planning the M&A Transaction, is part of the Private Company M&A Bootcamp for 2024 series and is sponsored by Mood, Max Asset, and Type to Learn. Slide 7 of the PowerPoint summarizes this episode, and slides 8 and 9 summarize the series. Speaking of the slides, we're not going to step through the PowerPoint in any kind of order, nor will you have to listen to us to regurgitate any of the slides. This webinar, like all Financial Poise webinars, is an informal conversation about the subject matter. You can keep the PowerPoint handy. I will, from time to time, click around on the deck to show you some of the things we may be talking about. You could also print out a hard copy if you're so inclined to take notes. We have a great panel today. We are joined by Jeremy Weitzman. Jeremy is a partner at the Chicago full-service law firm of Much Cellist. Having trained as an M&A attorney in big law, Jeremy represents businesses of all types and sizes, counsels companies throughout their life cycles, often through ownership's exit. He counsels privately held, middle market and emerging growth companies, family offices and funds, investors, C-level executives, boards of directors, family-owned businesses, and entrepreneurs in a myriad of M&A financings, M&A deals, financings, and other commercial matters. We have Bob Decker with us today. Bob is a career capital markets professional and operating executive with extensive experience working with companies ranging from emerging growth to large publicly traded companies. He specializes in developing and implementing creative capital formation strategies and advising clients on alternative approaches for maximizing shareholder value in connection with merger acquisition activities. We've got Tom Goldblatt with us today. Tom founded Ravinia Capital, Capital, an investment bank in 1998, and serves as managing partner. Businesses hire Ravinia Capital to sell companies, raise senior debt, junior capital, and equity, to advise sellers and buyers of businesses, and to structure, execute, and close transactions. Tom specializes in getting deals done and in developing creative solutions for transactions. Lastly, we've got Michael Weiss with us today. Michael is a principal of Weiss Bernie LLC, which is a boutique corporate and real estate transactional law firm in the Chicago metropolitan area. As a transactional legal veteran, Michael represents privately and publicly held entities in businesses and commercial transactions and handles the negotiation and closing of complex and corporate commercial real estate transactions, both domestically and internationally. He's also a certified public accountant, and his experience includes all aspects of mergers and acquisitions, securities, and corporate governance. I'm Robert London, your moderator. I'm an equity partner at Jasmine Schlesinger Narendran, which is a full-service law firm in Garden City, New York, just a stone's throw outside of Manhattan, where I negotiate business transactions on behalf of my clients. That includes M&A, obviously, startups, executive comp matters, and a bunch of other things. Basically, the way I look at myself as anything that's tough to negotiate and fun to draft, and vice versa, is what I do. Thanks for your patience thus far and listening to our credentials. It's not an infomercial. If you really want to learn more about us, you can look at the back of the deck. This webinar is a production of Financial Poise. More about Financial Poise can be found in the PowerPoint as well. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're listening or watching this on demand or have any questions after the webinar is live, you can send an email to info@Financial Poise. Remember, the PowerPoint and conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, an accountant, or other appropriate professional. In other words, if you take significant actions based on some of the things you may hear and learn today and things don't work out, silly you for not consulting a professional. Okay, let's get this started. I'm going to tap each panelist briefly, and we're going to start out very broadly with discussing what some of the primary types of M&A transactions are and what are some of the key similarities and how they're structured differently. I'm going to start with Jeremy, who's going to address asset deals. Jeremy, take it away.
Thanks, Rob, and thanks for having me today. So an asset deal at a 30,000-foot level is the seller selling the assets of its business to a particular buyer. So if you think about how companies are structured, you have owners, you have directors, you have officers, and then you have a bundle of assets. So in an asset sale structure, What's happening is a company which remains in existence is selling its assets to some other third party. At the end of that transaction, the company, again, which remains in existence, usually gets compensation, right? Some cash or other remuneration. So again, an asset sale is the sale of a company's assets. And what are the assets? The assets are intellectual property, contracts, perhaps employees. So it can be both tangible and intangible assets.
Thanks. Let's flip over to Michael. Michael, tell us about what a merger is and how you combine
Good afternoon,
companies.
everyone. A merger is a combination of two different entities. Typically corporations, but other entities may be allowed to be merged under various state laws. And it combines the balance sheets, the assets and liabilities of the merging companies, and one of the entities will be designated the survivor. Mergers are popular. They're generally structured as tax-free combinations, and they're used often when a purchase or a sale is not the desired transaction for contractual purposes or license purposes. So in summary, it's really the combination of two or more entities, with an entity surviving and an entity disappearing, being merged into the survivor.
Rob, you're on mute.
Sorry, let's talk about stock purchases. And I'll ask Tom to go ahead and do that while I hit the right mute click button.
Sure. Well, a stock purchase is where you're buying, you're stepping into the shoes of the seller, and you're getting everything. Unlike where Jeremy talked about an asset purchase, where you might get all of the assets or some of the assets, you might get none of the liabilities or assume some of the liabilities. In a stock sale, you basically step into the shoes of the previous company, and you get all of the equity, and you get the good and bad with that. You get any contracts that they have, any liabilities, any basis. So it goes a long way. It's also regulated as a security when it's a stock as opposed to an asset. So there's more scrutiny, but essentially the outcome is about the same. But as when we get into structure, there has very different ramifications for tax liabilities and other things.
Thanks. Let's close it out with Bob talking about two-step acquisitions.
Sure. Thanks, Rob. Well, basically, a two-step purchase structure could involve upfront either a majority or minority interest purchase by a buyer with typically a defined procedure for acquiring the remaining interest in the business. Two-step acquisitions process typically includes call provisions, which are pretty much purchase options for the buyer, or rights of first refusal to purchase any remaining seller interests. So there are a lot of different ways to structure two-step transactions, but basically some interest, majority or minority, is acquired up front with the expectation that the remaining shares or assets will be purchased at some future point in time by the buyer.
All right, listeners out there in the ether, that basically sums up the most of the types of M&A transactions. Now we're going to dig a little bit deeper, as well as try to get into the heads of some of our acquirers and sellers. Tom, let's talk about what the end game is for an acquirer. What would you advise acquired companies to be weighing and considering relative to integration activities as things present in the future post-acquisition, and how to plan for them out of the gate?
Well, again, we're talking about the main concerns and goals that drive structure here, right? So when you're figuring at the beginning what structure is going to be for you're really looking at the net effect of for both the buyer and seller, because whether it ends up one structure or another can have very different effects on the tax, the net tax. It can have very different effects on what liabilities end up being taken over by the buyer. Also, sometimes the structure goes, there really isn't a choice. There's one reason, like a public company maybe has to buy stock. So sometimes it's limited. But really, what's going on in the structure is trying to have a subtle negotiation between the two sides, trying to figure out, what the net value and what the other party can give. For instance, it may be that doing an asset sale, the biggest thing with the company is that they have potential product liabilities that are almost unknown in the millions. So the buyer would very much not want to do a stock, because they would be stuck with all sorts of unknown liabilities. On the other hand, if you do an asset sale, you don't get this tax basis transferred that were before for the other company. So it may be that one of the real attractive things of the selling company is that they have a multi-million-dollar tax loss carry forward that if you buy the stock, you can use, but it gets thrown away if you do the asset. So it's kind of balancing between the two parties and letting negotiating leverage end up in what is the best structure. Sometimes the structure can really change all the way down to the end when people start to really hone in on it. But the structure is looking to optimize the net proceeds over the long run for both the seller and the buyer.
Thanks. I'm going to ask Michael to dig a little bit deeper into tax planning, and private M&A tax efficiency planning, could on its own take up its own four-part series webinar. From the buy side and the sell side, in turn, are there any top level concerns, maybe touching upon some of the things that Tom hinted at? Any major pitfalls, Michael? What do you?
Yes, there absolutely are. And tax planning in a transaction is such an important part of the transaction. Whether you're on the buy side or the sell side, I would strongly advise to get your tax professionals involved as early and as often as possible. The analysis from the buy side, it goes beyond transactional tax, but or transactional structure. And let's talk about that. As a buyer, you generally want to buy and have a balance sheet with as much depreciation and amortization going forward. That's always a big concern for a buyer who wants to do an asset deal. They don't want to lose the benefit of that depreciation, especially if we're assuming an asset-heavy business, because it's a material part, depending on the business, could be a material part of the profit and loss statement. So it needs to be an analysis from the buy side, what kind of a deal works. I would also mention, and I'm seeing the last bunch of years, just state and local tax issues often don't get considered, especially in some type of retail business, and that's also an important issue that has to be analyzed. I was just recently involved in a transaction where there are a lot of questionable state and local tax accounting, and it becomes sort of material numbers. So from a buy side, you want the accountants to look at, the balance sheet, what type of assets are being purchased, sort of the history, if there's any pitfalls. Tom mentioned operating loss carry forwards. There's really a host of issues, and more than I could talk about in 5 minutes. So I would really just recommend that, tax due diligence is very important. And often those folks doing the due diligence have different specialties, state and local tax or transactional tax, and different types of assets. So very, very important to look at and get an analysis and a projection going forward as to what the depreciation amortization will be. And conversely, from the sell side, that's important. As a seller, a seller wants to know, not just what kind of cash or consideration am I getting from the transaction, what am I getting after taxes? What kind of taxes do I have to pay? Am I selling hot assets that is there income tax liability in there? So there's income tax liability, there's sales tax, there's structural tax, and tax advice is important. Also, to structure the deal, is there going to be will it be a stock deal with a 338 election, which we won't get into, which so there are ways to make a stock deal look like an asset deal, and so forth. I can't emphasize enough, and I think the panel would agree, just how important it is to analyze the tax issues and really get in the right professionals to conduct such analysis and due diligence.
Well, accountants and corporate tax departments of law firms hereby thank you for the free infomercial. Let's move it along. Jeremy, I'm sure you, like everyone here on the panel, have worked on a number of differently structured transactions. Can you give us an example of what type of transaction which has to take its form, based upon some sort of attribute of the subject business?
Sure. But before answering that, I really do want to echo what Michael just said. I think, especially first-time sellers, they specifically get caught up in the number. I want to sell my business for $10 million. But that $10 million can look very different at the end of the day, depending on whether it's an asset deal, stock deal, or one of the other transaction structures we talked about. So it's not really 10, it's what do I put in my pocket that's important. Moving on to your question, Rob. So there's a couple big things that come into mind. One is, you can look at something like the sale of a division, right? So if the business has been structured so that there's not separate businesses, if you have, ABC Co. Inc., right? And there's a sale arm and a wholesale arm and a manufacturing arm, and somebody comes along and they just want to buy the manufacturing arm, unless the company has been set up where you have separate specific companies, the only way to accomplish that would be to do an asset purchase, for example. So we were talking about before, you can buy the assets of the company. Well, in the connection with, for example, the sale of a division, right? The assets are going to be a defined variable, a set of variables that are specific to the manufacturing division, using my hypothetical. So that's one instance where, you're really limited in terms of the structure because of how the seller is set up. Another instance where you're sort of locked in is, let's say you're in a highly regulated industry that has a particular license. Well, in that instance, you're really limited to probably doing a stock deal because the entity itself is the one that has the license. So while tax aspects are usually the driver of the structure, there's other variables that can come into play as well. Sale of a division, if there's specific license that are tied to the actual ownership of the business, and things along those lines. So I would say, 1A is the tax, 1B is, are there other structural elements that are in play that you need to look at to structure the transaction?
Great. As a part of any acquisition, there's always transition planning, whether it's workforce, whether it's customers, whether it's accounts receivable. What leads up to an exit from the sell side point of view, Bob, in planning for those types of things, and what types of things are buyers most concerned about when dealing with sellers in that regard?
Yeah. So typically when we're advising a founder or family-owned business, and assuming there's not a next generation ready to step into the role of running the company, then the seller has several other considerations that they need to address from the outset. Putting aside the tax aspects, which is always a key component, as we've been talking about previously, Some of the other things that the seller will want to consider are management succession and their bench strength. You know, who can run this business separate from the owner who is getting liquidity in the business. Now, this is different depending on whether it is a private equity or financial buyer versus a strategic buyer. A strategic buyer may have their own management team that could come in and run the company, but typically a financial buyer is going to want to see some transition period with the existing management team and some bench strength of people that would continue to run the business. So the seller needs to decide, are they willing to continue with the business post-sale, whether as a member of the management team or potentially as a minority stockholder? So they want to consider, what is the proposed transaction structure? How much liquidity are they looking to get up front? If it's not all cash, what other forms of consideration are they willing to consider, such as seller notes, earnouts, continued equity participation, et cetera. Another factor that sellers sometimes we ask them to take into consideration is, how important are their employees to the business? And could the employees actually be a viable contender to purchase the business under an ESOP structure, which we won't get into the details right now, but there are tax advantages under selling to a group of existing workers in the business. But basically, whenever we're working with sellers, we try to get them to start thinking 2 to 3 years in advance on these matters. So, you know, all their tax planning and succession planning and, you know, post transaction. When you're doing a corporate divestiture, that's a little bit of a different animal. For a selling corporation, really one of the key considerations is to make sure that you compile a reasonable set of financial statements that represent what that business or those assets that are being sold, what they would look like on a standalone basis. So those are the things that we suggest sellers take into consideration.
Thanks a lot. Let's go over to Tom. Still wearing our sell side hat. Can you address what steps the sell side should take at the very, very start of the transaction? We do have a separate episode in this series about, I think it's called The Process, which sounds kind of fun and scary at the same time, where we take a deeper dive into this, but maybe give us a little bit of a preview here.
Sure. Yeah. And Bob did a good job of kind of leading into this. So some of it's overlap, and he is correct. If you can have 2 or 3 years before, all the better. But it's really something that the earlier you start thinking about it, the more strategic, the better your outcome is going to be, because there's things that you can adjust early on. So one of the first things to do, besides like deciding, you know, where we want to explore this, is to start to put your team together of advisors. So it's good at a very early stage to get referred to a good investment bank, like some of those on this call that really have been around, done deals, and can start to advise of what's going to be good and bad. Same thing with attorneys and accountants. Start to get your team together. Who are the key employees at the company as well, and then you want to start to think about getting organized and getting, you know, make sure everything's clear cut, and put a plan in action with these advisors to start to think about what's the timing. Is there some big event coming, good or bad, to your company that might affect things? Is there something going on in your life? Is there something going on in the macroeconomic climate that makes it a good or bad part of, if you're a cyclical company? So you're going to want to start to get organized. You're going to want to start to take care of some things maybe that are going to be problems later that you can address. So if there's open-ended lawsuits, it might be something to really put more pressure on getting done. If you have like write-offs and losses, stuff you want to kind of clean up. So it's very analogous, as everybody's familiar with selling a house. You want to get it in order before you sell it. You want to make it presentable, and it's applicable to selling. Once you kind of are getting going and organizing, the investment banker is going to start to put together certain materials to run the process. So we'll just preview it, but besides, getting the information organized in what's now an electric data room, virtual data rooms, which are a fantastic development. When a lot of us started our career, everything was in a real data room, and it was a lot more cumbersome and difficult to share documents and everything. Now it's all electronic. You're going to have the investment bank start to put together documents to tell the story. There's principally two documents. There's one that's a longer form, what's called a CIM, confidential information memorandum, which could either be a PowerPoint or a memorandum. It's basically about 20 to 80 pages, depending on the situation. And a very important document, often overlooked, is what's called a teaser. And this is a 1 to 3 page document, which really conveys the company, the opportunity, but it does it in generally an anonymous form, because you're going to want to kind of keep things confidential. You're going to also want to kind of start to putting a strategy together of communication within the company. Who's going to know? What's going to be the way it's going to be communicated? Ultimately, by the time you get to the end, your whole company is going full open kimono, and so everybody knows everything. But at the beginning, a lot of things are very sensitive. So these are some of the things. It's really just a preview of the upcoming webinar, but that's a lot of the things start to put together. Start to think about what things you can eliminate. For instance, there's like concentration or key man issues that could later make a company worth less. Meaning, if you own a company and you're just really key and you're taking all the buyers out on a fishing trip to Canada and it's all pivots around you, that's not a good thing. As much as you might feel pride in that, it's going to make your company less saleable. So maybe starting years out, you can start to, kind of pull yourself out of the business and have somebody replace that a firm coming in would feel that is going to be continuous with the business. And there's other things like that, but the more time, the better. But often we don't have that.
It's actually a pretty interesting point, because especially in mid-market and smaller private M&A, the need to sell arises when there's no next generation to run the family business. So there isn't that stronger mid, or general manager to promote, because it's always been kept close to the family, but now the next generation doesn't want it. So being ahead of the game sometimes is just not possible. So
I'll just add, you got to think about a lot of people are used to running their company day to day, and you got to think about it as from the buyer's viewpoint. And the buyer is looking to establish their price based on two things. It's going to be, what is the potential additional cash flow that it's going to generate to them, whether they buy the company outright or merge it into theirs, and what's the risk of achieving that? So the more that you can kind of show that your cash flow is stable and not risky and higher, the better your ultimate price is going to be.
all right, well, let's now let Bob bring us into the buyer's TP here, and escape Tom's kimono. Let's talk a little bit about buyer's point of view, both from transition and planning to planning the deal going forward, perhaps once it gets the teaser, for example.
Well, when we work with buyers, obviously one of the first thing to consider is there a process in place? Meaning, is the seller working with an advisor where they've already planned, they know they want to sell the business? Or there are circumstances where you're working with buyers where you are going out and perhaps making unsolicited offers to a seller. Those are very different situations. If there's a formal sale process in place, seller, as Tom had mentioned before, will typically have all of their due diligence put together in a virtual data room. They'll have bidding procedures spelled out. There will be a group of buyers that are identified, and it's a process that has been set up to get done within a certain specified period of time. Now, if a buyer is coming in with an unsolicited offer, that is very different. under those circumstances, it's really incumbent on the buyer to put together a detailed due diligence list. What are the things that they want to know about management, earnings, everything else. And it can be a longer process to do that, particularly if the buyer is not working. I'm sorry, if the seller is not working with an advisor. But nevertheless, when a buyer is contacting a potential seller unsolicited, presumably that buyer already knows quite a bit about the target, including their product lines, the channels that they're selling through, geographic overlap, et cetera. And they have a real rationale for approaching the target. However, before making an offer, whether unsolicited or as part of a formal sale process, the buyer will want to have in mind some idea of how they are going to finance the transaction. How much leverage do they think that they can take on to do this acquisition, whether it's bank financing or other types of financing. And then once a transaction gets under a letter of intent, the buyer will now begin thinking about post-merger integration matters. That will encompass such areas as, management, employee retention. Who do they want to keep? Who don't they want to keep? These are all issues that you really want to address before you get to closing. They want to look at customer and supplier overlap. Is that going to be a challenge, or is that going to be beneficial to the transaction? What sort of systems do they have? Management information, financial, et cetera, and how will that integration go? Are there specific facilities or assets that might be excluded from the purchase price or might be divested post-acquisition? And then, ultimately, before you get down to signing a purchase and sale agreement, the buyer is going to want to make sure that whatever representations and warranties that the seller is making, that they can back those up. And they have some way to protect themselves in case those reps or warranties are breached. So,
Great, very thorough. Let's talk a little bit about buyer preference, Michael. Sometimes buyers gravitate towards the asset purchase because they think it's the easiest, best Teflon non-stick way to avoid seller liabilities. Even if it's less likely that a buyer will be or that'll be free of those type of liabilities. Are there that it's more likely that they'll be free? Is there a legal theory somehow where even if they do an asset deal, depending on certain circumstances, that they might get stuck?
Yes. We don't see it a lot in our practice, and I think that's probably true for most of the panel because most of our clients have good legal representation and really prevent liability from a buyer's side. But there is some risk. Two issues really come to mind. The first is risk that's set out in some sort of a law or a statute. And the classic example is sales tax. Many states require some type of reporting requirement, could be tax or other issue, by the buyer or seller of the transaction. I'm thinking of Illinois, for example, for state tax, and sort of you get an assessment of what taxes are owed by a seller, and then there could be a holdback. And if that procedure is not followed, there could be exposure to the buyer to be responsible for the seller's liabilities. So as a buyer, have to be aware of what's out there in the law and what has to, whether it's statute or regulation or something, and to follow all of that, or else a buyer may be stuck with certain sellers' liabilities that were not intended. And we're going to talk about indemnification later, but we don't, as a buyer, I don't necessarily want to just rely on indemnification from a seller, because then I I have to chase somebody. Also, there's sort of a fuzzier concept of successor liability, meaning a buyer, even though they did not acquire the stock, is still responsible for the liabilities of the seller. If there's the buyer acts like they've taken over the liabilities, corresponds with contracts of the seller, even though they didn't assume the contracts, keeps up the same business. And then, sort of the seller's vendors may say, hey, I didn't know that you weren't responsible. So it's very fact specific and case by case and circumstances, but there is a chance that a buyer may be held liable based on its actions, post closing. And that becomes highlighted and more sensitive, especially if there's similar officers and directors on the sell side as there is on the buy side. And that often happens that a buyer team is composed of part of the seller team and just buying out a company. So it's very fact specific. It's called successor liability. And, if the names are similar and there's, the legal entities are not really structured right, and there's a lot of overlap, again, very fact specific and not necessarily easy to prove, but there may be successor liability on a buyer where it wasn't intended. Sort of acting like you've assumed the liabilities, even though legally you haven't. A court may impose, successor liability there, and we've all seen it happen.
Okay, Jeremy. So on the one hand, protect yourself against seller liabilities. On the other hand, what would be the benefit to maybe not having an asset deal if there are any?
So we talked about this briefly before, and it was the kind of license scenario, right? The selling entity has some specific license. Let's take like a restaurant, for example. Restaurants likely have, liquor licenses. Those licenses are tied to the entity, most likely in most jurisdictions. So if you bought the tables and the food product and everything else, well, that doesn't do you a lot of good if you got to come in and start waiting 6 months to get a liquor license issued, right? So in that scenario, you would want to buy the stock. Other instances of that would be, let's say there's a business that has 100 customer contracts, which are maybe they're signable, maybe they're not. In contracts, you'll have that magic language that this may not be assigned without the written consent of the other party. Well, if that's the language, then you need to go and start sending out notices to 100 different customers to get their consent. A lot of times, contracts are not written with respect to what's called a change of control, meaning the people that own the entity on day one continue to own the entity on day two. So under that structure, take those same 100 customer contracts. If you did it as a stock deal, then there's not a consent needed because the company owned it before, the company owns it after. It's just who owns the company that has changed, right? So that's an instance where for lots of reasons, for notice reasons, for logistical reasons, you may want to just buy the stock in the entity. And yeah, you're going to take some of the skeletons that go with it, but hopefully if you have a good counsel on your side, you'll either have a holdback or an escrow or something where you'll have indemnification protection for those skeletons. So it's the logistical elements that may necessitate it. The other thing that we talked about, Michael, when he was talking about taxes earlier in our webinar here, I think briefly mentioned a 338H10. And one of the beyond the liability issues, one of the reasons that most buyers will prefer an asset sale over a stock sale is because then they get the step up in basis on the assets. Whereas in a stock deal, you don't necessarily get that. there are certain situations and cases, again, beyond the scope of this webinar, but where you can make what's called a 338H10 election that will allow that buyer to get that same kind of step up basis in the assets to be able to appreciate it post closing, and you kind of narrow the gap. And some of this, we talked earlier about what's the bottom line to that seller, right? It may be beneficial, to do a stock deal so that the seller gets capital gains treatment. The 338H10 kind of shifts some of the burden on that, but a lot of times what you see is, and Tom and Bob can speak to this better than me, is, a way to split the difference on pricing is maybe you increase the price, but you do a 338H10. Anyway, there's some, so this is where, again, having good advisors on the investment banking side, on the tax side, on the legal side, can help, if there's a gap in what the buyer and seller want, to maybe get pretty close to both sides. But that may also be a driver that allows you to do, a stock deal where somebody else might want to do an asset deal. So again, facts and circumstances, but there are situations where, even though an asset deal may be the gold standard for a buyer, a stock deal makes more sense.
Thanks. To preview, I think the next episode in this series, Key Provisions, bear in mind that just because you might need 30 third-party consents in an asset deal, there are ways around that, where you might isolate as a closing condition getting the material ones and have a post-closing covenant for the seller to cooperate with you to get you the immaterial ones post-closing, or at least give you the economic benefits of it. So it's not necessarily game over. There's a way to maybe to do that, and check out the next webinar. All right, I think we've beaten up structure a lot, which is the main focus of this webinar, but I think we'd be well served starting to talk about the consideration and the money and the value. And I'm going to tap Tom to sort of put on his seller's hat again, and figure out what are some of the best and available ways for a seller to get paid in a transaction.
Sure, Rob. And when you're talking about getting paid, it's really about again, it's about the probability of what you're going to get over the long haul. And so cash is obviously great at closing because you got it and you walk away. Sometimes, though, and particularly these days, there's a lot of discrepancy between what's the value of a company, because it's always uncertain what the future will hold. And so there's ways to bridge that gap by maybe making it part cash, but also part in what's called an earnout, which would be based on the performance of the company later. And there's different ways to do that. It could be where they get a certain amount of stock and in the entity, and there's a million ways to cut that. But really what the overall thinking is, if you're a seller, is you're thinking about making sure that you get what you bargained for. So at the beginning, you have all sorts of leverage until the close because you own the company, you're operating the company, the buyer wants the company. So you have a lot of leverage. You don't have to worry about a lot of things, and you put everything into the contract. As a lot of people know, after you close, enforcing a contract is not necessarily so simple. Even if it says something in black and white, you have to kind of take a person to court. It takes time. There's uncertainty in that, and that's not really a great format. So there's other ways to structure things to alleviate some of that risk. So there's things called holdbacks and escrows, basically, so that you have the money sitting with a third party, so that if something later you're supposed to be paid by the other party for a damage or as part of the purchase price, it's much more clean to just go into that third party escrow and pull it out. So there's a lot of different things. Now, as a seller, a seller advisor, we really try to advise our clients against earnouts as much, or structure them in a way that's not so risky. Because once you sell your company, the buyer takes it over and they can run it in all sorts of ways. So if you make it based off of a profit or something, they can make adjustments. Maybe your company gets merged into other companies and it becomes, they can take certain client accounts out. So you want to make it as objective as possible. I personally like giving my clients like a, an interest at pari passu or on the same terms as the seller has in the interest. But there's these things, we'll get into this in some later webinars. There's a lot of different thinking, but it's really all about like thinking about down the line and eliminating that risk of getting paid and who's going to carry the risk of the market or something going wrong and allocating that risk.
Thanks. I'm going to skip around a little bit and tap Bob. We just talked a little bit about how the seller would like to be paid. Let's flip this around from the buyer's point of view, and how the buyer is coming up with what it's going to pay out. Let's say a financial advisor's found a buyer which is willing to pay more for my business than any other company which is approached, but there's a catch. That buyer wants to finance a large portion of the purchase price. Are third-party financings customary? What are the seller's risks? What are the buyer's motivations? And then if you could sort of close it out a little bit with what are some of the potential contingencies out there and what you see in the market as far as buyers holding back purchase price, all sorts of holdbacks with respect to diligence and the like. So, generally, contingent financing and holdbacks are the topic I'd like you to kind of briefly address.
Sure. So I think there were a couple of questions in there, Rob. So I'll do my best to try to address those.
It's also interesting, and we're running out of time. I want to get it all.
I got it. So first of all, you were asking about the risk. It is not unusual for a buyer to use, particularly a financial buyer or PE firm, to use leverage to make an acquisition. While leverage ratios today are not nearly as high as they were at kind of the peak M&A market pre-pandemic, think 3.5 to 4.5 times leverage. That's based on EBITDA multiples versus, in some cases, they were as high as 6 or 7 times, maybe 5 years ago. But there are still a lot of additional risk associated with doing a leverage transaction. Typically in these circumstances, the cash consideration that's being paid to a seller comes from a combination of buyer's liquidity and other sources of financing. So it is critical that the seller know upfront, how is the buyer structuring this? How much leverage are they proposing to put on this deal? Higher leverage, there's a higher risk that the deal could fall apart because of financing issues. The seller will also want to know upfront, is this a fully committed financing package, or is there a contingency? Is there an out? Ideally, a financial buyer would come to the table with a fully committed financing, in which case concerns about financing are moot. But more often, the financing is not committed until the deal structure has been finalized purchase price, and the lenders performed all of their due diligence. And this presents risk to the seller if the financing drops out along the way. And part of that consideration, too, is how much of the purchase price is being paid in cash versus other forms of consideration, such as seller notes or earnouts. The higher the leverage there is, the bigger the risk there is that those contingent forms of payment might not get paid. One of the things that we advise sellers is if there is a financing contingency in there, we oftentimes try to negotiate what's called a breakup fee. And in this instance, the buyer may have to put a down payment in, some percentage of the purchase price. And if the deal falls apart, then the seller is entitled to keep that down payment. That's really the cost of, the buyer trying to put together a contingent financing deal. But really, at the end of the day, a seller just wants to make sure that there's not too much leverage on the business, either that the deal's going to fall apart in due diligence, or that they put at risk any of their earnouts, seller notes, or any other future consideration that's going to be paid.
Okay. Jeremy, let's talk about what a private company on the sell side should be aware of, common pitfalls at the very early stages, because the webinar is both structuring and planning. To me, it all sort of starts with a willing seller's plan of sale. What can you counsel there?
So a couple things, and I know we're short on time, so I'll try and keep this brief. A couple things are, one, to make sure you get NDAs in place, non-disclosure agreements, meaning you're going to be providing to, investment bankers, potential buyers, lots of folks, very sensitive, confidential information, the secret sauce, if you will, to your business. And so it's imperative that you get good NDAs in place at the front end before anything's disclosed, ideally, so that you're protected. That if they happen to get it and use it, you have a contract that you can then take to court to hopefully shut that down and potentially seek damages. The second thing, and this is where for the brief instance in the transaction where it may not be aligned with Bob and Tom on our advice, is the negotiation of your financial advisory engagement, right? So there's lots of terms there that are negotiable. Obviously, some of it comes down to are you on paper the best thing ever, or are you or is the intermediary doing you a favor by even helping you, right? So, but there's lots of things in that document that is negotiable, such as the payment structure, the credit of, perhaps if there's a retainer that's called for, is that going to be offset against the success fee? When the success fee is paid, most of the time it's at closing, but what if there's contingent consideration along the lines of what we were talking about before? Does the investment banker get a present value of that? Do they get it when you get it? Or do they get everything that's contemplated? The other thing that often gets negotiated is the tail. So how long after the engagement ends does that investment banker entitled to a commission if you have a deal? Are there things like known suitors that you've already had preliminary discussions with when you bring in that investment banker or business broker? So all of these things can lead to some negotiation around what is the compensation, when is it paid, how is it paid, and again, when you're representing the seller, and then you got to negotiate that document, and then you're on the same side as that person. It can lead to some awkward exchanges depending on how those go. But assuming everybody is reasonable and asking for fair things, then usually once you get over that first hump, then you're best friends and toasting at the end of the deal. So, but it is something that is important and that needs to be negotiated.
Yep.
I've always wondered or wished that Financial Poise would allow for like a deeper dive on some of this stuff. I would love to have a mock negotiation on a financial advisory fee letter, just so that they could see both sides. They could see where fairness dictates and where people could end up. Because on the one hand, although the financial advisors bring on the sell side, bring the deal home, on the other side, I've had many a client who consults counsel way too late. Once they've already signed one of these, with a 2-year tail and no carve out for already parties that were already known, and as part of the planning process goes, talk to us sooner.
Yeah, I mean, I think that I feel it works best when you align the interests, and so that given the situation, the investment bank is trying to be incentivized for the outcome that the seller really wants. Sometimes we have a situation where it could be a sale, it could be a debt raise, and it's like, and there might be a lower amount for the debt, even though the seller would prefer that. So I like to make sure we're all kind of thinking the same thing, we're aligned and incentivized in the same way, and I think goes better then.
And look, obviously I'm the attorney, and most attorneys think they're the smartest person in the room. I will tell you from my experience, and I've done over 150 M&A deals in my career, a good investment banker is worth their fee times infinity, because they are the difference sometimes between a deal getting done and not getting done, and even beyond that, it's opening up their wallet, right? If you go to the business broker on the corner of the street, they may be good, but they may be terrible. And if you get a terrible one, they're not worth anything. A good one that can introduce you to contacts that you may not have access to. It's like showing your house, right? You can list a house by yourself, and maybe you get 15 buyers. A good broker is going to know how to advertise. A good broker is going to know how to bring people in. And instead of having 15 potential possibilities, you now have 300. A good investment banker, business broker, same thing, right? So it's going to maximize. Yeah, maybe you're going to have a multi-$100,000 fee to an investment banker, depending on the size of your deal. And guess what? They got you 15 million more for your business. I don't know about you, but I'd gladly pay an extra $500,000 to make 20 million at the end of the day.
Well, I think I'm going to bring Jeremy to our next pitch.
I was thinking the same thing.
But it's true. It's true. I've seen it firsthand. So anyway.
I'm going to have Michael very briefly close us out a little bit, talking about due diligence, a little bit about the process, and a little bit about some types of boogeymen that might come up during due diligence that really messes with potential integration and the deal together. Then I'll say goodbye for all of us.
We're ending on a very important issue. The way due diligence will often work, let's talk about it from the buyer side. Naturally, is the buyer will send out a checklist to the seller, and the checklist could come from the buyer or professionals the buyer has engaged, such as the insurance guys, the environmental guys, the operation guys, with a whole bunch of information that the buyer would like to see. And there's usually some part of due diligence. Now, some of this is done very early in the process, sort of a basic teaser, a very limited package, and then as we get to an LOI or towards signing a purchase agreement, it gets more extensive. And as Tom mentioned, now we have these wonderful electronic data rooms, and for us old guys, it's been just wonderful. And the information comes in and gets distributed to those who need to review it. And it's a very thorough, very important process from the buyer side to really know what you're buying. And so due diligence, very important. I know Tom and I and maybe others, Jeremy, we're accountants by trade, and we like to look at the financial statements line by line and understand what it's all about. So due diligence, very important. And I will say, just as a war story, I think many deals that are not successful are because buyers have failed to do proper due diligence. Either they hired sort of the wrong professionals to evaluate the information, or they weren't willing to spend the time or the money, and the problems they had later in the deal were right there in front of their face, so to speak, but they either glossed over it just in their eagerness to do a deal, to get a deal done. And also, as Tom said, after the fact, after the deal closes, it's very difficult to pull out the contract and say, well, seller, you didn't do this, you didn't do that, that's not right, that's not wrong. So I can't stress enough how important it is to really go in and do due diligence. Now, very quickly, from a seller standpoint, a seller is usually willing to cooperate. to the extent that it can and to the extent that it doesn't really distract their business. What a seller wants is, or doesn't want the buyer to interview, every employee and get his take on everything, because they generally want to keep the transactions confidential to the rank and file. But a very important process of the transaction, very important.
Great. Thanks a lot, everyone. This was a fun one. Thanks again to our sponsors, Mood, Max Asset, and Type to Learn. You can learn more about them on slides 3 and 4 of the deck. Thank you for another entertaining yet educational production of Financial Poise. You can look for Financial Poise webinars wherever better continuing education webinars are sold. Please join me on September 10 for episode 2 of the 2024 M&A Bootcamp entitled Key Provisions in M&A Agreements. I don't know what the panel will consist of, but I'm hoping that it's some or all of the folks who helped us here today. Have a great day, everyone, and thanks again.
Thanks, everybody.
Thanks all.